Hello and welcome to this edition of the Good Pious Media class. Now let me inform us that the videos will be dropping at weekends only, okay? Because that is when I'm actually available to drop these videos, to prepare and produce these videos and drop them. So always expect them either Saturday night or anytime on Sunday, okay? Certainly you will be getting them by weekends. Now, in our last class, when we dealt with the definition of defamation and of course the conditions precedents for you to say this is an act of defamation, which I mentioned as having to do with publication, malice, causing damage, and so on and so forth. I told us that our next class was going to be centered on the defense for defamation. What does that mean? That means that if somebody accuses you of defamation, as a matter of fact, if somebody files a suit against you over alleged defamation, in this case now as a media person, okay, we are not looking at it from the broader perspective, although the same rule applies even if you are not a journalist or you are not a media person and there is an allegation of defamation against you, perhaps over what you have said or what you have written against somebody. The same rules apply. But in this case, it's about the media because we are talking about the media here. So, as a journalist, assuming somebody files a defamation case against you, how do you defend yourself? What are you going to plead your defense with? So these are some of the things that we are going to be looking at in this particular class. And so the class is tagged the defense to defamation cases. Now, there are basically 8 ways, okay, or 8 defenses a journalist could pick from depending on the level or the nature of the allegation against you. There are 8 different defenses that you could pick from to suit the nature of the allegation. Now, the first one is what you call justification or truth. Okay? Now, for you to want to use this particular criterion as a defense for defamation, when you talk about justification or truth, what does that mean? That means that what you have said or written about the plaintiff now is the person suing you, okay? The person instituting a case against you is the plaintiff, while you are the defender or the defendant rather, okay? Now, if what you have said is truth, is the truth, okay? If you think that what you have said or written against the person who is suing you is the truth and you can justify it, then you already have a case for yourself. But for you to do that, it means you must prove that what you said about that person is truth, or to a very large extent, the truth. And that also means that even if you call somebody name and what you have said about that person happens to be the truth, then the person does not have the justification to defame you. I mean, to sue you for defamation. That is not defamation. The truth, when you say the truth, don't forget in our earlier class we said that when what you say about somebody is false. That's one of the criteria. It is malicious, etc. So in this case, when what you have said or written about somebody is true, on condition that you can prove the truth with undeniable evidence, then automatically you can plead or you can defend that publication. So that's number one. That's what we call justification or truth. Now, the next one is what you call the res judicata. I think I talked about this briefly in one of our previous classes. Res judicata, Latin word, it's a common legal term for lawyers. I think they understand this better. Simply means that a matter has been taken to a logical conclusion, to a logical end, which means that that matter, has been taken to the court, and either of the parties, either the plaintiff or the defendant, has won or lost the case. So if that is the case, once that matter has been decided in court, you can plead, you can use that as a defense that such a matter, the same matter, action cannot be filed against you on the same matter again. You need to be picking out some of these things so that you know. That's why I said whichever defense you want to use depends on the nature of the defamation case instituted against you as a journalist. Now, we've talked about justification or truth. That's one. And now we are talking about res judicata. I told you, is a Latin term for it, which means that a matter has been taken to a logical conclusion. So it can no longer be adjudicated upon legally. So you can use that as a defense if that matter, the same matter, had been taken to court and judgment had been made on it. Whether you won or you lost, whether the defense won or lost, that matter cannot be looked at again in the same court. So if you are taken to court on such a matter, you already know what to plead. Now there's another one called the principle of fair comment. Fair comment here means that as a journalist, of course, the Constitution empowers you to hold government accountable for the people, and of course to uphold, morally, socially, and even legally, the values of the Nigerian state. Therefore, if you are to make a statement as a journalist, either as a presenter or as an analyst, provided you are a practicing journalist, and then a case is instituted against you for defamation, you can now rely on this particular defense that the law empowers you to make such comments or to write such comments or statements, while holding governments accountable and upholding the values of the nation. In other words, you don't do it out of bias. You must be fair in your comments, and you don't do it out of malice, and then you don't express it, very important, as a matter of fact. You express it as opinion. And this one goes mostly to those who play the role of analysts on the air. And that is why if you are an analyst and you want to say something that you are not very sure of, you don't have the evidence, you don't come out to say that it is a fact. You can always tie it down to say it's your opinion. For as long as the comment, is not malicious and then it is not biased. It's not intended to damage the reputation of the person you are making the comment against. Take for instance, you're on a radio program and they are talking about a politician who probably has embezzled money. You look at the matter and you try to analyze it and come up with a position, whether for or against the person. Of course, usually when it is against the person that they sue you for, defamation. So in that case, you have not done anything wrong. You're only analyzing a situation and trying to hold maybe a public officer to account. So if such a person comes to sue you for defamation in such a situation, you already know what to plead based on what I have said. Okay? And that's the principle of fair comment. No bias. You are saying it the way it is for public interest. For public interest. And then we have what you call privileges. Okay? Now, this one is simple. There are certain kinds of professions that enjoy certain privileges to do certain things, of which the profession that we practice is one: the media, journalism, broadcasting. You are covered by certain chapters of the Constitution. So there are certain aspects of the Constitution that give us the right to practice journalism. Okay, just like it gave powers to the executive, to the legislature, and to the judiciary. The only other institution that was mentioned, that was given such powers in the Constitution, is the media. And that's why, like I told you in our previous class, the media is seen as the fourth estate of the realm. So you enjoy certain privileges as a media person to criticize and hold the government and the society to account without anybody using that against you. On condition, of course, that it is not malicious and it is not intended to damage the reputation of anyone. So that is why, as media people, we have to be very careful and stick with some of these principles so that you would be able to defend yourself when such matters come up against you. Okay? It is not when you use languages that amount to bias, amount to falsehood, okay, amount to malice, and yet you want to come and plead or use that as a defense because you are a journalist. It will not fly. Okay? So you have to keep to your own side of the bargain. And that's why some of these principles we are mentioning are very, very important. There is another one, which is consent to publication. Now, this means that when somebody invites you for an interview and willingly grants you an interview, such a person cannot now turn around and use the same interview granted you to sue you for defamation. Okay? It's not possible. Unless, of course, you have gone beyond the limits of the interview. Unless you have gone to quote or say something that the person did not say in the course of the interview. You have gone ahead to impute your own details, okay, outside the realms of what that person has said. And what you have imputed happens to be damaging to the image of that person. Then you will definitely go in for it as a journalist. Of course, no trained journalist would want to do that. You will definitely stick to the content of the interview. And this also means that you must always have your facts, particularly the recording of that interview, intact, so that if there is any issue, you would be able to provide, the evidence that you didn't go beyond your bounds, you didn't go beyond the interview. It is what is contained in that interview that you have published. In that case, you have already made a defense for yourself. Okay? That is talking about the principle of consent of publication. Yes, the next one is the death of the plaintiff. Don't forget, I told you that the plaintiff is the person who is suing you, okay, who is filing a litigation against you on account of alleged defamation. Now, defamation is a personal thing. Once anybody who is suing you for defamation dies, technically that matter dies automatically with the person because it's a personal thing. Okay? By law, no other person has the power to prosecute you apart from the person who is claiming defamation. So if you have a strong case with somebody and the person happens to die, I mean a strong defamation case as a journalist, and the person happens to die, perhaps you technically have escaped that litigation, especially if you would have been found guilty at the end of the day. So take note of that. It's one way you can also plead your defense. Should the person in question die in the course of the case or before the case was even instituted, then there will be no case at all. That's another defense for you. Okay? Yes, the number 7th one is the one that is referred to as accord and satisfaction. What this means is simply that when there was an allegation of a defamation case, both of you were able to reach a satisfactory agreement, okay, a satisfactory consensus, let me put it that way, that both of you are satisfied with the outcome of your agreement on the matter. Okay? Yeah, perhaps you accuse me of defamation. Maybe I tried to explain to you, I tried to plead with you, and both of us came to an understanding that at the end of the day that we have decided to let go the matter. Okay? And there is an evidence to that effect. You cannot be charged for the same matter again. So you can use that as a defense that both of you had already agreed and settled this matter amicably to the satisfaction of both of you. So taking the matter to court again does not stand legally. Okay? So it does not stand, and that is what we call accord and satisfaction. And then the last but not the least of them is what you call innocent dissemination. Now, a journalist can also hide under the fact that some of the reports that they disseminated, provided it's not emanating from you directly, you didn't conduct the interview, but probably you got it from what you can call a reliable source. Of course, if you find a report in some conventional media outfits and prints, you take it that reports coming from these sources must be credible, must be authentic. So you decide to share, you decide to disseminate that. You could easily plead your case that this did not emanate from you, you saw it from an authentic source, and you ignorantly, underline that word, ignorantly disseminated it. So by law, you could plead your case and ask the law to excuse you from that matter. So much so that you are not going to be joined, okay, as a defendant in that matter, and as such, you are not going to be held responsible for the outcome or the dissemination of that material. But again, this also reminds us as journalists that we must always verify every information and be almost 100% sure of the authenticity before we go ahead to disseminate. I think that's one of the hallmarks of a good journalist. Lastly, we have talked about some of these defenses. So, how do you remedy issues of defamation? Yes, there are ways of remedying defamation, okay? Without necessarily going to court, defamation can be remedied. The first means to remedy defamation is to pay for damages. So if as a journalist, you have defamed somebody and you have agreed that truly you defamed that person, you will have to pay for the damages. Whatever the person charges you, you will have to pay. That's one way to remedy defamation. So you see that we have to be very careful in whatever we do. Another great point is retraction and correction, or retraction or correction. Okay, retraction means taking down or taking back whatever you said about the person publicly. You have to go to the public and say that whatever it is that was said about this person is not true. Okay, and you are retracting it, you are taking it back. That is what retraction means. Correction could mean that there are portions of that publication that actually caused the problem. So you can go and correct portions of that publication, that by updating it, editing that part that caused the problem, and so on and so forth. But the most important thing is that at the end of the day, it has been corrected. Yes, this one is very common among media outfits, very, very common, and that is publication of admittance of fault and tendering of apology. You admit you are at fault and you offer public apology, the same medium through which you defamed that person. Okay, is the same medium through which you will also tender the apology, so that the same people who read about the defamation will be the same people who will also read about the fact that whatever it is that was said against this person in the past was actually not correct. It was said in error. And all of these are done in order to make amends, okay, and then save that image which your defamation had already destroyed. So these are some of the things, and I hope that we've been able to learn one or two things in this class today. Trust me, if you follow it critically, there is no way you would not have picked one thing at the end of the day. Okay, so do well to share this content, and of course, if you are yet to subscribe to this my YouTube page, Coach Pius Media Class, kindly go and do so. Like I told you, there are so many things you would learn as far as this class is concerned.